It's official. The federal government has banned hemp-derived cannabinoids. Congress passed it, the president signed it, and now the clock is ticking. If you make, sell, or even distribute hemp-derived products, you need to understand what's in this law, when it takes effect, and how it's going to reshape the hemp industry. Stay with me in the next few minutes. We'll break it down. What the new federal ban actually says, what the timeline looks like before enforcement begins, and how state laws, including Tennessee, come into play, and what you can do right now to protect your business. Let's get into it. So on November 12, 2025, as part of a large government funding package, Congress passed, the president signed, House Resolution 5371. Buried inside that bill is a sweeping federal ban on hemp and hemp-derived cannabinoids, which most of us know as HDCs. That law takes effect 1 year from the signing date, meaning enforcement begins November 12, 2026. Now, this isn't a small change in terminology. The bill redefines hemp-derived cannabinoids under what's called a total THC standard. That means the combined amount of THC class cannabinoids can't exceed 0.3% total THC in intermediate products or 0.4 milligrams per retail package. There is also language in the bill that allows only naturally occurring cannabinoids found in the plant. The FDA is required by the bill to provide a list of these naturally occurring cannabinoids within 90 days of bill signing. This could signal the end of Delta-8, Delta-10, HHC, THCP, and all the other hemp-based cannabinoids. Let me put that into perspective. Under these limits, nearly every hemp-derived cannabinoid product on the market today would be considered illegal at the federal level. So here's what the new law actually says. It criminalizes distribution and possession of HDC products that contain cannabinoids not naturally produced by the hemp plant or those synthesized outside of it. Bans marketing or selling intermediate HDC products directly to consumers, limits THC class cannabinoids to that 0.3% total or 0.4 milligrams per container, and it directs the FDA within 90 days to publish a comprehensive list of all naturally occurring cannabinoids and those with THC-like effects. Once that list is out, expect enforcement and compliance guidance to ramp up fast. So what's the good news? Is there any? Well, the federal ban does not automatically override state law. That means states with existing hemp regulatory systems like Tennessee, Kentucky, Florida, and others still control their own definitions and enforcement, at least temporarily. For example, in Tennessee, currently, licensed business can continue to sell hemp-derived products with less than 0.3% Delta-9 THC through June of 2026, even after this federal law takes effect. Why? Because the Tennessee General Assembly hasn't yet updated its state statutes, and federal law doesn't instantly rewrite state law. But here's the catch. That protection is short-lived. Once states reconvene their legislative sessions, they'll likely have to decide whether to align with the new federal standard. So while you may be in the clear today, the countdown is already on for the need to lobby your state legislature. So if you're in the hemp space, whether you're a grower, extractor, retailer, manufacturer, here's what you can be doing now, not next year. Review your formulations and COAs. Make sure you know your cannabinoids and check your COAs to make sure. Reevaluate your supply chain. If your inputs or products include synthesized cannabinoids, they'll be at high risk under this new law. And plan for state-level changes. Track your state legislature's activity. They're going to be under pressure to respond to this new federal law. And stay engaged and vocal. This isn't over. We have a looming farm bill that could address the overstep in the recently passed bill. Lawmakers and regulators will be hearing from the industry throughout the next year as implementation unfolds. And if you need help figuring out where your business stands or how to stay compliant under both federal and state law, our team at Hemp Law Group is here to help. You can schedule a 15-minute compliance consultation with me directly. The link is in the description below. The bottom line is this: the federal hemp-derived cannabinoid market as we've known it is coming to an end, at least under current definitions. But that doesn't mean the industry ends. It means it's changing and fast. So don't wait for regulators to show up at your door. Stay informed, stay proactive, and make sure you have a compliance plan in place before these new rules kick in. I'm Clint Palmer with the Hemp Law Group. Please subscribe to our channel for all updates and check out our blog, which will link in the description below. Thanks for watching and stay tuned as we keep tracking what comes next for the hemp industry.